witnesses for being here today. My line of questioning is going to be on the freedom of speech and expression. The Canadian Constitution Foundation has raised concern about the civil liberties implications of Bill C-8, subclause 15.2. Would give the minister the ability to make decisions to kick someone off the internet. So my question would be, what safeguards are in place to prevent the government from using cybersecurity as a pretext for silencing speech?
Thank you, Mr. Chair, for the question. Certainly appreciate the importance of the subject raised. There are protections at the outset, during the use of the authority, and after the fact. So, for instance, the policy objective specifies the protection of the Canadian telecommunications system as the overarching scope of action. So individual speech has no bearing on the ability of Bell Canada or Rogers to maintain its network or the reliability of its services. That just has no relation there. There's a further precision that the use of the authority needs to be reasonable to the gravity of the nature of the threat that you're trying to combat. And there are criteria established by the Supreme Court in over many decades, but including in the 2019 Vavilov decision that specifies what reasonableness will be. There's other oversight and reporting requirements, including to NCIRA and SECOP, and then finally to Parliament.
Okay, thank you for that. Well, it seems that if this legislation is passed within its current form, unamended, we are going to be giving the Minister of Industry the sweeping power with virtually no checks or balances. In theory, the minister could wake up one morning, as one of my other colleagues referred, and not be impressed by a post on social media going further to basically that it says it poses a threat to our telecommunications services. Without a warrant, without a trial, without any automatic judicial review, the minister could compel Rogers or TELUS to go and seek these people's private data. So what do you have to say about that?
Thank you, Mr. Chair, for the question. Would note the scoping mechanisms that limit any action with respect to the disconnection of services. Furthermore, to the question about personal data. So first, the scoping applies to those considerations as well. So again, like the personal data or browsing history of individual Canadians are not germane to the underlying maintenance or reliability of the telecommunications infrastructure in question. There is a further amendment that was adopted when the bill was C-26 that for greater certainty explicitly prohibits the use. This was already prohibited, but it adds just an extra level of clarity that the order-making powers cannot be used to intercept private communications.
So what measures could be put in place to ensure that this isn't misused or worse, turned into a political tool for the Liberal government against people or organizations that they disagree with?
Thank you, Mr. Chair, for the question. Maybe I would ultimately what the committee decides is the committee's prerogative, so I can't speak on behalf of the committee. I would note that the set of authorities that were introduced with the bill and that were adopted in the previous committee study that, again, add for protection both in the outset of the scoping. So the concerns that are raised are already prohibited within the scoping of the law currently. There are consultation requirements that allow for additional kind of oversight and consideration of the use of those powers. And then there are notification requirements and reporting requirements, including for the narrow confidential use of authorities that ensure oversight.
I have a final question. Multiple civil society groups have raised concern about federal governments trying to grant themselves the power of intrusion on our private lives and under the name of security. Have these organizations been genuinely consulted before the development of this bill?
You have about 15 seconds.
So the short answer is that yes, we received multiple submissions from civil liberties organizations, and I can say for sure that my team looked at them, studied them very carefully, and considered them very carefully, and including submissions that were made to the committee in the previous Parliament, we studied those very carefully.